Yes, sir. We got a very good afternoon to everyone present here. I am Trinav Sharma, the moderator for today's interactive session organized by LawInternships. We have amongst us Mr. Rahul Tiwari, sir. Sir, we welcome you. Sir has completed his legal education from New Law College, Bharatiya Vidyapeeth, Pune. He has also obtained his LLM with 8.35 CGPA, specializing in cybercrime and economic offense. Sir has strong passion for legal research and public speaking. He's the founding and managing partner of LNS Associate, which is an MCA registered law firm. This firm also offers online legal education and training to law students and fresh graduates. He's also a panel member of World Cybersecurity Forum, WCSF. He has presented 25 research papers in various international and national seminars and has publications in prestigious journals, including the UGC approved. Apart from legal practice and research, he loves teaching students of school and colleges. He has been invited as guest speaker on 11 webinars where he taught law students about basics of criminal and constitutional law. He has taught 240 students in criminal law through certificate courses. He has also been invited as judge for various debate competitions, national moot competitions, and bail application competition. He has worked as an associate and litigation from Lamba and Lamba, Gurugram. Sir is now practicing in Delhi High Court and Gurugram District Court. We welcome to you, sir.
Thank you for this
Sir,
kind introduction. Yeah.
Sir will be discussing on how to draft complaint under check dishonor under section 138 of Negotiable Instrument Act. If anyone has any query, yes, sir. If anyone has,
yeah, tell me.
No, sir, I'm like, yes, sir, continue, sir.
Okay. So I think all the participants have, just have gone through both the modules. First module deals with the legal notice part, and the second module deals with the entire drafting of your criminal complaint. So what actually happens that, check dishonor cases are one of the rarest cases where, because if we see in the nature of the case, it's a civil case, but the check dishonor case are one of the rarest rare civil cases which are tried in a magistrate court. And if the case is in the magistrate court, then we can safely assume that
military base.
Excuse me. Excuse me. Hello. Okay, so these are the few cases which are actually dealt in the magistrate court, and by magistrate court it means that it has a criminal nature involved in it. So because this was the essence, that if someone takes a check and he does if someone issues a check in favor of someone and he borrows the money, and if it doesn't return, then it is deemed as a criminal offense. And for that, if you read the section, it is the punishment is up to 2 years or fine, or it is both. And the case are tried either in the section 406 or 420. Always remember one thing, that section 406 talks about the criminal breach of trust, and section 420 talks about regarding the cheating. So both the offenses are different in nature, and these are the two offenses which are always either of the one. These are always read with they are read with the section 138 of NI Act. So now let's quickly see what is there in the module 1. So first of all, suppose module 1, because I'm teaching a certificate course, so I've just shared because there I've given all the students approximately 18 modules, and I've just shared 2 modules with you where of my course, and both the modules are drafted by me. So first module is talks about the legal notice and importance of legal notice in various cases, whether it is property cases, whether it's consumer cases, or whether it's a negotiable instrument cases, and what are the actual importance of the legal notice in the check bounce cases. So first, like someone has issued a check to a person and has borrowed a money, and then that person is not returning. That person intimidates the accused that I'm going to place the check in the bank, so kindly update your account. So and after that he deposited the check in the account, and the check gets dishonored. Then he gets the bank memo and the original check returned to the complainant by the bank itself. And in the bank memo, the reason it will be specified that what was the reason that why the check was dishonored. So after you receive the check, I mean, suppose and see, in the check dishonor cases, it is extremely important to understand. You have to take care about the limitation period in mind. So, suppose a check was submitted in the bank on suppose 1st of January, it gets dishonored, and you receive the bank memo on the 3rd of January. So it was dishonored on it will be deemed as it was dishonored on 3rd of January, and then from 3rd of January you get 30 days time to send the legal notice first. Okay. And if you don't send a legal notice, then automatically it changes the nature of the case. I mean, it will get converted into a civil case then, and then it will no longer remain a check dishonor case under Section 138 of CRPC. Rather than it will be dealt as a suit for recovery cases in the civil court. And for that, you have to deposit, court fees, and then you have to fight the case. But in the check dishonor case, if you keep this thing in mind that you send the legal notice within 30 days, and obviously you always send the legal notice via speed post. Okay. And in the speed post, what actually happened that you track down all the details that yes, the notice was served, you send the legal notice by speed post, and then you track down the report, and it shows that now the notice has been delivered or the notice has been returned to you. So you start counting the day. I mean, you send the legal notice, okay, and then you start counting you start counting the 15 days period that yes, I have sent the legal notice. The notice is you send the legal notice on 4th of January. The legal notice is received by the accused, suppose on 6th of January. Then you wait for 15 days. 15 days means from 6th of January to 20th of January. Okay, you wait for 15 days so that the accused gives you a reply, and then if he replies to your legal notice, and if he says that yes, I'm ready to settle the matter, if he returns the money, then well and good. If he does not return the money, then from 20th of January, you get another period of 30 days time to file the check bounce cases. Okay. And if you fail to do so, and suppose you approach the court on the 40th day, then you have to file the condonation of delay application separately, which is filed under Section 5 of Limitation Act 1963. So always remember, whenever you're drafting a negotiable instrument act cases, this is the specific formula: 30, 15, 30. 30 days to send the legal notice. After sending the legal notice, you wait for 15 days. Okay, so that the accused can reply to a legal notice. And if he does not reply to a legal notice, see, and if you think that he's not going to reply to a legal notice, and you go on to file the case, and you go on to file the case on the 30th day itself, then the problem is that then your case will be dismissed. Okay, I mean, it will be disposed of, and the court will ask you to file the case once the period is over. Once this 15 days period is over, only then you can file the case. You cannot even file the case on the 15th day itself. Okay. And it was in one of the important judgment. I'll send that judgment, the judgment copy to the organizers. You can read it. That in that Supreme Court simply said, it was I guess Yashwant versus Rita. I've used the judgment, but I'll send it to you. Don't worry. So in that, the Supreme Court clearly said that unless till the time the 15 days period is over, you cannot go and file the uh, Negotiable Instrument Act cases until the check notice period is over. Okay, and then when the notice period is over, and only then you go and file the or you go and file the your Negotiable Instrument Act. So very quickly, let's see. Just a second, I'll be back. There's some noise in my background, so that's why I'm not able to concentrate. Okay. So in the module 2, if you see in the module 1, I've said, I have specifically written that when you send the legal notice, always try to send the legal notice by speed post. And when you send the legal notice by the speed post, you save the postal tracking number. Okay. And then because that postal tracking number, that postal receipt and your tracking report works as an important evidence in the first filing of your negotiable instrument cases under section 138 CRPC. So on the first page, you write down in the court of judicial magistrate first class Gurgaon, and then in the matter of complainant name, accused name, index, and then the first point is the memos of the parties. Memos of the parties means all the details of the parties. And then the second point is your criminal complaint, and then your list of witness, and then it is followed by your annexures, and then pre-submitting of evidence, Vakalatnama and Talban. Talban is basically, it's approximately a 50 rupees court fees. That's it. Okay. So it is extremely important that first of all, see, in the legal notice part, have I attached the legal notice? Yes, if you can see the legal notice, that same legal notice is the legal notice which you can see in the module 1. It is the same legal notice which I use, which is used as an important annexures in while you are drafting your negotiable instrument act case, your complaint. So on the, please check now, and on the second page, on the memos of the parties, it's written the complainant and the accused, and then in the memos of the party, you write down the entire details of the complainant, that the complainant name, age, and its address, and you highlight it as a complainant versus the accused name, accused age, and its address. And then if you see the language, because I have a paucity of time and usually I take like 2 to 3 hours to explain all this concept in detail. So if you see the language of legal notice, I have also explained that what is the, if you read the legal notice module, I have written that registered AD means registered address on which the legal notice is sent. So and the subject of the legal notice is that dishonor of the check, and then you write down that that the complainant was a social person, was a person of social repute, and then you befriended that person, and then you took that loan, and then for a surety you issued this check, and then after a lot of negotiation, when you didn't return the money, the complainant approached the bank and issued the bank and deposited the check in the bank, and it got dishonored. So kindly return the money within 15 days, and then within 15 days, along with the litigation cost. So this is the language of your legal notice, and the entire all those same material facts are then simply used in your criminal complaint also, except that from the first page, from the second or third point, you also start writing the annexures also, because in the legal notice, see, what is legal notice? Legal notice is your final warning that either you rectify my damages or else I'm going to initiate a criminal case against you. It is acts as a final warning. And criminal complaint is one where you go and simply tell the court that yes, I had sent the legal notice. Remember, in check bounce cases, if you don't send the legal notice, the case will not be admitted in the court. This is one of the most essential element of the legal notice, especially in the check bounce cases and also in the consumer cases also. So when you start drafting, see, and before moving forward, I would like to also explain you and very important feature of drafting. See, drafting is what is drafting basically? Drafting is nothing but drafting is nothing but it's your language of your research work. So better your research work is, that better will be your drafting. Okay, so always remember, and a second important thing is that you will learn drafting only when you drafted all the points completely, because you should know what should come at the top. See, because check bounce cases are of two types. It is either at the individual level or at the corporate level. Like suppose there are a lot of NBFC companies where where a lot of people apply for business loan, and then as a surety they produce a check to them that we'll return this money, and for a surety purpose you take the signed check by us, and obviously the date is not mentioned on those checks. And at the personal level, suppose there are two friends or relatives, and a person is in financial need, and that person takes a loan, like I need 5 lakh rupees from you, and they issue like a check as a surety to them. Okay, so if the person, if it is from if the loan is taken at the individual level, then you have to explain you have, in the first point you have to explain that the person was of social repute, and the person had a very good relation with them, and that is why he issued the check. Okay, but in the second case, when the loan is taken from the uh, when the loan is taken from the NBFC company, then you have to explain that this company is a registered company. This company has the right to issue. Company possesses the right to issue loan to the people, and they can charge interest for that. They are authorized to do that, and usually, and if you see the affidavit part, then in the affidavit part, the complainant writes all the details regarding himself, that yes, I understand all these things. It's written in the language in which I can understand, and all the other verifications. But if the loan is taken from a finance company, then usually it is represented by an AR. AR means authorized representative. Okay, so authorized representative is one who will sign the criminal complaint, and if it is taken at the individual level, then the complainant signs the criminal complaint. Okay, so from the first part, it is similar to what you have written in the legal notice, that the complainant was a person of social repute, and then because the accused needed money, and they knew each other from a very long period. They had a visitation right to each other home, at their houses also. They used to visit each other homes regularly, and then they developed a very genuine relation, and that is why the person and that is the reason why the person took loan from the complainant to fulfill his financial obligations. And then in the third part, you will write that the third part I've mentioned additionally. It is when, because it is, suppose, see, if the person has taken loan at an individual level, then you don't write this third part. This third part is when we are working under some advocate, and usually they get a lot of panel cases. And panel cases means they have a lot of finance companies, and they are representing their cases, and usually they get cases around. Usually, even a small finance company, provide check bounce cases. I mean, the cases are in usually 500 cases or 600 cases. So this third point is for them, that you try to explain that the company actually has the right to issue loan, and and the person has deliberately failed to repay. Deliberately failed to repay the loan which he has taken from the finance company. And then you in the fourth point, you write about all the details of the check which the accused has issued. Like suppose the accused has issued the SBI check, so you will say that the accused issued then a checkbook of SBI, and the check number was this. The amount written on the check was this much, and the branch from which the check was issued was this. So you have to like, it can be like SBI Bank of XYZ branch from Gurgaon. From Gurgaon. So you write all the details about which is mentioned in the checkbook. Okay, and then what was the and see, if it is taken as an if the loan is taken at the individual level, then the agreement copy works as an annexure one. Okay, if you see in the point number 2, I have written that the copy of the loan agreement is annexed as an annexure one. Okay, and that original check, okay, in which the amount was written, which was deposited in the bank, it acts as an annexure 2. And then in the 5th point, you say you write that the on the assurance of the complainant, the on the assurance of the accused, the complainant went and deposited the check in his bank, and now the complainant banks can be the same bank. Also, like the complainant and accused can have the bank in the SBI, or the accused can issue a check of ICICI Bank, and the complainant has an account in HDFC Bank, and he can deposit his check in HDFC Bank also. So no harm in that. Okay, so there you will write down the all the details of the check again, that the check that the complainant deposited the check in his bank. The check number was this, then the amount was this, and the date. Now the important thing is date, because the once you have written a date on the check, the validity of the check starts, and the validity to encash the check is always the 90 days period. So, and that's why I've highlighted that, in drafting more in this point number 5 and point number 6, this is the area where most of the fresher commits a lot of mistakes. Even I have committed a lot of mistakes while drafting the check bounce petition, and it was this area where most of the people actually commits a lot of mistake. Okay, so that is the reason why I've highlighted module 2, page number 5. Okay, if you see the point number 5 and 6, module 2, page number 5. Okay, so if you see, and then you write down that the amount, that state check of check number this, amount this, date written on this check was this, the complainant deposited the check in this bank, and it get dishonored, and the reason of dishonored was this. It can be like fund insufficient, account close, signature didn't match, or date ambiguous. There are a lot of reasons why the check gets dishonored, and then you mention the reason of the dishonor, and then you write while drafting this complaint, that the copy of the return memo from the bank is annexed as annexure A3. And if you scroll it down, I have also annexed a lot of annexures also for your better understanding. And then you say and then the next point to draft is that after receiving the bank memo, the complainant the complainant sent a statutory legal notice to the accused on this day, and the legal notice was sent on this day. So see, both the legal, suppose I sent a legal notice, or I drafted a legal notice on 27th of February, okay, and I sent the legal notice via speed post on 28th of February. So here the dates can be same also, the date can be different also. Okay, that you have to check whether, because see, when your senior will give you that, okay, this is the legal notice, draft a complaint. So you while you are when you are drafting the point number 6, you will see, okay, the date written on the legal notice is this, and then you will turn on the legal notice, so that postal receipt is pasted on that envelope. Okay, so you see the date. So suppose the date can be like the legal notice was sent on 22nd of February, and it was sent by a speed post, and legal notice under section 138 of Negotiable Instrument Act, and it was sent via a registered speed post to the accused person on this date. And then on the day it was sent, on the day when the legal notice was sent, then you write down that date, and then you say that in that legal notice you explained all the terms and condition of the agreement, and you also write down that the accused actually actually the accused has the legal liability towards the complainant to repay back the loan. And then you write last point you write is that the copy of the legal notice and the postal receipt are annexed as annexure A4 and A5, and then the copy of the postal receipt is also annexed as annexure A6. So now here is the biggest catch. While where people also make mistake is that suppose the legal notice is sent on 27th of February. Okay, the accused receives the legal notice on 3rd March. Okay, so his 15 days period will start from 3rd March, and then you calculate 3rd March, like from 3rd March, 3 to 10, 8 days, and then 17th of March. Okay, so till 17th of March, you cannot go and file a criminal case. You have to wait for that period to get over, and then from 17th March, once the 15 days period is over, then calculate from 18th March to 30 days. You have time of you have a prescribed period of 30 days from 18th of March. It can be like 18th of March. If you calculate 18th of March till either 16th of April or 17th of April, you have to look at to see the calendar. Okay, and you get this 30 days period to file this complaint. And then in the second part, you said that the in the seventh part you write that the aforesaid notice served upon was in accordance to the law. Okay, and despite the notice, and then you write down the grievance that even when the notice was served to the accused didn't reply it, although he knows that he has a legal liabilities to be discharged towards the complainant. And then one of the important things is that you also write down that the address of the accused, you also mentioned that the address of the, because see, in the when you're drafting, you have to explain each and everything to the court, that the address of the accused is also the last known address which was there in the knowledge of the complainant. And uh, even after the even after receiving the legal notice, the even after receiving the legal notice, the accused deliberately tried to evade his legal liabilities towards the complainant. And then you write down each all these things that that despite the serving of legal notice, the accused waited for a 15 days period and he didn't get a reply. And then he didn't get a reply on, or he failed to make a payment. And then you write it down that then you try, you tell the court from your via drafting that here's what the offense was committed, and the offense was committed in the section of 138 of negotiable instrument, and that is the reason why we have approached this court. Okay, and then on the last point, on the 11th, you last thing, see, first you tell that the accused has taken the loan, accused issued a check, date of the details of the check was deposited in this bank, it gets dishonored, bank memo, legal notice was sent, you waited for 15 days, 15 days period got over, and then you send the legal notice. You had also sent the legal notice on the last registered address also, and hence the accused has committed an offense. Offense under section 138 CRB of Negotiable Instrument Act. And in the last point, you tell the court that that the bank where the cause of action has arisen falls under the jurisdiction of this honorable court. And then you mention all these things. And the last point is that the complaint which we have drafted is under the limitation period. So regarding the limitation period, I guess I have explained you, like you have to always keep this thing in mind, like 30, 15 and 30. Okay, and then your prayer, where you pray that kindly summon the accused and award the maximum punishment provided by the law, as he has committed the offense in section 138 of Negotiable Instrument Act, and to pass an order to, because in check bounce cases you can ask for both the things. You can ask for the and you should actually ask for both the thing, because then if you ask for just for one thing in the prayer and then you file another suit, if the judgment is not passed, then it comes under res sub judice. Or if the judgment is, if the court has given the order, then you'll fall under the res judicata, because you are trying to try to waste the time of the court, and it will lead to multiplicity of the petitions. Okay, and always remember one thing regarding the jurisdiction part. Remember like this: suppose the accused lives in Noida, okay, complainant lives in Gurgaon, and the bank where the complainant has deposited the check and where it got dishonored is in Delhi. So you will only file the case in Delhi because the cause of action has arisen in Delhi. You are not going to file the case in Noida where the accused is residing, or in Gurgaon where the complainant is residing. In check bounce cases specifically, it is mentioned that it is always the court where it is always filed in the court which has the jurisdiction over the bank where the cause of action has arisen. And see, in when you come into the litigation, this is one of the most confusing thing also, because often a lot of time even I've committed the same mistake, because the client didn't knew the exact address, and even I got confused because usually because the courts has the particular police stations, like sector 29 police station, sector 30, section 37, Shashank police station under this court, and these police stations under this court. So actually what actually happened, that sometimes, because even the accused was ill-informed, and he said, no sir, I'm 100% sure that this bank falls under the section 29 police station, and actually it was, and later on I realized that that court, that bank was opposite side of the road, and it falls under the jurisdiction of another police station. So always remember one thing, and that is why the jurisdiction and the cause of action are extremely important in all the drafting part which you do, and especially when you start with the you will start litigation from your lower court. Always remember the jurisdiction part is extremely important. And that is why I'm taking a little bit time more in explaining you the technicalities of the jurisdiction. So now, what are the basic difference? Like, technicalities of the case and merits of the case. Merits of the case is that was the check issued, was it given out of fear, or it was taken forcefully, and was there a loan agreement, and what was the source of income of the complainant? These are the merits of the case. And what was the reason, what was the reason for the dishonor of the check, when the and what are the evidences, what are all other evidences which the accused has, which the complainant has against the accused. These are the merits of the case, and the technical grounds are that was the legal notice served on time? Okay, was the criminal complaint was filed on time? And do all the and is there any technical mistake in the criminal complaint? Like, are they having all these annexures in the are they having all the annexures in the criminal complaint? Okay, so these are the technical ground, and obviously your command over. See, everyone knows about the basics of law. Everyone knows what is section 138, 142, and in fact any other sections of the law. But your command over the technical aspect of the law will only show that how good your practice is. Okay, and that is the most important part, because actually you have all the knowledge, okay, but you don't know how to draft a petition, and your command over technical aspect of the law is weak. And then what will happen, that you will go and file a case in the wrong court, okay, which doesn't have the territorial jurisdiction to try that matter, or you will miss out in annexing few of the important you'll miss out in annexing few of the important documents also. Okay, so these are the technical ground. So now, moving forward, after prayer, it is always supported by an affidavit. The affidavit format is extremely same party names in the court of judicial, because judicial magistrate first class, it is always tried in the judicial magistrate first class, as it is mentioned in section 138 CR of Negotiable Instrument Act. And then it is followed by the list of witness and the documents, like what all the documents I'm annexing with this criminal complaint. It is the loan agreement, original check, along with the date written, the bank memo date, the legal notice, and the postal receipt part. And then moving forward is your pre-summoning of evidence. So pre-summoning is something that it acts as a second affidavit of your criminal complaint. So everything which you have written, in the criminal complaint is you can just copy and paste it over here, and only there will be two changes. Like in the criminal complaint you write that it is the criminal complaint filed under section 138 of CRPC, and you start with most respectfully show it that, and then you start writing down. But in the pre-summoning is that, see, what do you mean by the term pre-summoning? Pre-summoning means that before summoning of the accused, I am submitting all these evidences in the court to consider my case. So this is the meaning of pre-summoning. Like suppose you are interning somewhere and you are just typing without knowing that what is pre-summoning, and if your senior asks that what do you mean by pre-summoning of evidence, then you can you will be knowing that what is the correct answer. Okay, so in the pre-summoning, everything remains same except for the first line, that it start instead of most respectfully show it. Instead of that, it starts with an affidavit of complainant, the name of the complainant, the age, resident, and all these things, and then all the contents remain same. Okay, and then and the other changes are that in the complaint it is written as annexures. Okay, and in the pre-summoning it is written as exhibit CW 1 by 2, and the same chronology. So now, what do you mean by annexures and exhibit? Because it, out of curiosity, the doubts arise. Annexures means all those evidences which we are going to annex with this criminal complaint, and exhibit means all those evidences which we have annexed with this criminal complaint, we are exhibiting towards the court. So that is why in pre-summoning, we write exhibit CW, means complainant witness. Exhibit means we are exhibiting towards this court. And in the last part, after the prayer, in the pre-summoning, pre-summoning, there is no prayer, and then it just says the verification that you verify each and everything that it is correct and to the best of your knowledge. And now please open page number 13 of module 3. You can see this is the original check, and in the original check, if you can see, I have highlighted something with the pink line. Okay, so what is that? It is that with the red pen you write it, you write on the original check that it is the EX CW 1 by 1 or 1 by 2, whatever the annexure denominates, and then judicial magistrate first class Gurugram or any other court, and below that it is written on the below the JMIC Gurgaon, the date is written when you are filing the case. Okay, and then your annexure 3 is if you can see this thing, bank memo on the page number 14, and then your legal notice is your annexure 5, and then your postal receipt. See, it's where you can find out the date on the legal notice, and the date on the postal receipt can either be same or it can be different. So how you draft it, that you attach the legal notice, and that the postal receipt, you paste it on the paper, write down the party's name, and above that you can write it down that this is my 6th annexure. And then if you can see, this is the postal receipt that you you tell the court that see, the last line, see, the legal notice was sent on the 22nd of August, and it was item delivery confirmed, means the accused has received the item. Okay, the accused has received the legal notice, and from 24th of August your limitation period will start. Okay, to file the criminal complaint. Okay, and from the next day of the legal of the receipt of the legal notice. And how you can confirm that? The delivery confirmed on the last column. If you can see delivery I have actually hidden the date. Okay, because it was revealing few other things also. If you can see that item delivery, delivery confirmed on, see, delivery location, DLF, SO, and the last, if you can see the last column, that delivery confirmed on. So you have to start counting 15 days from that day. Okay, so now sometimes what happens that many times the accused is not at home, or he has left his home, or he refused, and the postman is not able to find the accused. Then your legal notice then you receive your legal notice back. Okay, this is what happened. So if you see, so you have to just make one changes, that in the annexure, you after writing the reason of the dishonor, you also write that yes, I sent the legal notice also, and what actually, and to the surprise, the accused was not at this address, and the notice was returned to you. If you can see the point number 5, page number 20, module 2. Okay, if you see, you have you mentioned that the you received the legal notice back, and you on the legal notice, they actually highlight the reason why they were not able to deliver the legal notice to the accused, or the or to the person who was supposed to receive the legal notice. You write the reason, that addressee left, or there are any a lot of reason also, and for that I have given you one judgment. Okay, I've given you one judgment, that in that judgment it says, or under section 27 of general clause act, it says that when you have done your part, and if it is delivered, and see, interpretation of this judgment was that that if the accused is not at the address, and you have it was registered in his name, and you get the legal notice back, then it will be deemed to be served. Even then, you have to wait for 15 days. Okay, you have to, because our court works on the principle of audi alteram partem. Okay, and it means that everyone has right to be heard, and obviously the court will hear the contention of the accused also. So that is where you have to wait again for 15 days, and then after keeping this point, you have to file the criminal complaint. And only changes will be that the notice which you have received, received back by speed post, because it was not delivered to you, you annex that envelope also, in which the legal notice was signed. And always remember, when you are compiling the files, just remember the postal receipt which you get after your give when you give the notice at the filing counter in the post office. They give you a slip. Okay, that works as a postal receipt. But suppose the notice was not delivered because the addressee has left, and you get that legal notice back. And when you are compiling the file and you are annexing both the postal receipt and the envelope, just ensure that usually in most of the cases, what actually happens, that the lawyers are told two addresses, okay, regarding the accused. And suppose if one legal notice is received or sent or not, and one notice is returned. Okay, so while compiling the criminal complaint file, just ensure that the number written on the postal receipt and the number written on the envelope are same. And usually, actually, what happens in other cases also, you send multiple notices to the accused. Okay, so just ensure, because the court will look into this part, that the postal receipt which you are annexing, and the postal and the envelope, the returned envelope, the number of the post office number on both are same. Okay, and obviously, if you don't do it, then obviously the you'll get very a rude treatment from your senior. Okay, and also if it's your client, then obviously if it gets rejected with a malified intention, then obviously you lose out your client also. So this was your basic thing, and this was the reason I've shared the module also, that so that you can you understand that what is the actual format of the criminal complaint. Okay, about the criminal complaint, which is drafted under section 138 of NI Act. But trust me, just having this just having this module or sample draft will help you nothing. If you see in the Google, you will find a lot of sample petition of NI Act cases under Section 138, or even you will find a lot of sample for the writ petitions also. But you will learn only when you do it by yourself, and the how you learn is only by practice. Like you have to practice every day for approximately half an hour every day. Only then you will get a command that yes, first is the next part, then memos part, then list of witness, then the complaint, then followed by the affidavit, then pre-summoning, and then the list of next steps. If you do it regularly, only then you will learn. Otherwise, it will be just another theoretical knowledge, and obviously this webinar certificate or any other certificate will just remain a certificate, and in the longer course you will not get the actual benefit. So this was the this was my basic guide, what you call it, not even class, because class regarding the legal module, the module 1 and modules 2, which you must have received as of now, I usually take like at least 2 to 3 hours to explain the all the details of the legal, starting from the legal notice part and uh, till the filing of the criminal complaint. Okay, and because it was just a one-off webinar, so I just thought that I should share the modules with you, and then I can explain you. I can explain you everything in a brief manner, because if you can see, I was getting confused that yes, should I explain this part also? Should I explain this part also? Because if I start explaining each and every details of all those 40 pages which I have sent, then obviously it would have taken a lot of time, and also I have a class in the evening, my certificate course class. So obviously there was a paucity of time, but I just hope that just by going through my module, most of your queries will be solved. Okay, thank you. So if someone has any questions, they can ask.
Thank you very much, sir. Yeah. So if anyone has any questions or any queries, please feel free to ask sir, or you can write in the chat box also.
Interns, please feel free to ask your doubts.
I guess they don't have any doubt. So I guess we can end this session now. Okay.
Trinam, you may proceed with the vote of thanks.
Thank you, sir. Further, I would like to move with the vote of thanks. I, Trinam Sharma, on behalf of Team Law Internships, would like to extend my heartfelt gratitude to Mr. Rahul Tiwari, sir, for taking out time from his busy schedule and interacting with young minds. It was truly an enriching session, sir. Thank you again, sir, for sharing such wonderful knowledge and experience with us.
Thank you.
Thank you, sir.
Thank you, sir. Thank you for coming here. It was a great session. Thank you for sharing your knowledge. So I'll be ending the meeting here.